Hey everyone, it's Rob Ryder. It's August 6th, 2013. I believe it's August 6th, yeah, 2013, Tuesday. On the quest to find justice, that myself and some others are going to go look at the church. In fact, I've already sent my petition off to the Pope, sending it by way of the Cardinal, who's in charge of the Pontifical Council for the Laity. But as I was looking at stuff, I had come across this before about ordinaries, and when I read it again closer, but let's just read it because I think there's somebody in the county that can help us. So what's an ordinary? Is an officer of a church or civic authority who by reason of office has ordinary power to execute laws. Now, there is the thing that sets an ordinary apart from everybody else. She has the power to execute laws. Remember that, power to execute laws. Such officers are found in hierarchical organized churches of Western Christianity, which have an ecclesiastic law system. Now, as I pointed out in a video here recently, if you look at what a constitution is, and a constitution is an ecclesiastic ordinance, whereas a civil ordinance is considered a law. So anybody who has a constitution, it's an ecclesiastic law system. In the Episcopal Church, for example, an ordinary is the diocesan bishop. That would make sense. The bishop in an Episcopal church is the ordinary. Eastern Christianity has their own versions, but within civil governance, notably in the southern United States, the role of the county ordinary historically involved the discharge of certain, often legal and legally related tasks falling to city and county authorities, such as licensing marriages and adjudicating claims against an authority. Let's stop there for a minute. What our real problem is, forget that they're committing fraud, the people who brought this shit in the court, and they're not filling out their paperwork right, and there's no sworn complaint, and you put a sworn complaint in and nobody pays attention to it, and you do all these things and don't pay attention to it. What is the problem? The problem is with the authority. So in a court case, the problem is the judge, because he's going to render a willfully false judgment based on perjury of witnesses. So I want to go find the county ordinary and say, hey, the judge is rendering a willfully false judgment based on perjury. We need to take our complaint to the county ordinary. We'll see why here in a little bit. Again, I'm just reading, this is out of Wikipedia, right? So I'm just trying to read what Wikipedia says. In canon law, the power to govern the church is divided into a power to make laws, that's legislative, enforce the laws, that's executive, and judge as based on the law, that's judicial. And the ordinary is the one who has the power to enforce the laws. A person exercises power to govern either because the person holds an office to which the law grants governing power, or because someone with governing power has delegated it to that person. Ordinary power is the former, while the latter is delegated power. Okay, so the ordinary power is the person exercising power to govern either because a person holds an office to which the law grants governing power, right? He holds an office which the law grants governing power. Or someone with governing power has it delegated to that person. That's delegated power. The office with ordinary power could possess the governing power itself, that's proper ordinary power, or instead could have the ordinary power of agency, the inherent power to exercise someone else's power, vicarious ordinary power. Well, that's ways to use ordinary. The law vesting ordinary power could either be, okay, so the law vesting ordinary power could either be ecclesiastic law, the positive enactments that the church has established for itself, or divine law, the law which the church believes were given to it by God. So either way, whoever has ordinary power got it from a church, because ecclesiastic law has to do with religion and divine law has to do with God. Right? The ecclesiastic law are the laws of a particular church, and then divine law is just the law of God. So there is no separation of church and state. There's somebody sitting there in the county who has ordinary power through ecclesiastic and divine law, and they have the power to legislate, execute the law, and judge the law, or judge by the law. An example of a divinely instituted ordinaries: Catholics in communion with the Holy See believe that when Jesus established church, he also established the episcopate, the primacy of Simon Peter, endowing the offices with power to govern the church. In the Catholic Church, the office of successor of Simon Peter and the office of diocesan bishop possessed their ordinary power, even in the absence of positive enactments from the church. So again, ecclesiastic law is the positive enactments, and divine law is believe they have it by right of God. So the Catholic Church says they have it by the right of God, by divine law. Many officers possess ordinary power, but due to their lack of ordinary executive power, are not called ordinaries. The best example of this phenomenon is the office of judicial vicar. So what that means is the judge doesn't have executive power. He can't execute the law. He can only judge by the law. And the problem is the judge isn't judging by the law, he's judging by custom. And so, again, we need to take our complaint about that to the ordinary who has executive power. The judicial vicar only has authority through his office to exercise the diocesan bishop's power to judge cases. Though the vicar has vicarious ordinary judicial power, he is not an ordinary because he lacks ordinary executive power. It's the executive power. That's the one that's the important one. That's what makes that man the ordinary. He has executive power. A vicar general, however, has authority through his office to exercise a diocesan bishop's executive power. He is therefore an ordinary because of this vicarious ordinary executive power. So a vicar general can execute the law because he's getting his power to exercise from the bishop. And then this is just a bunch of different who's who in the zoo as far as ordinaries. Also classified as local ordinaries, as they do not have a particular church or equivalent community, are the vicar general and an episcopal vicar. They're both considered ordinaries having executive ordinary power. Ordinaries who are not local ordinaries, major superior religious institutions, abbots, societies of episcopal life, okay, they're not local ordinaries. In the Orthodox Church, a hierarchical ruling bishop holds uncontested authority within the boundaries of his own diocese. In the Orthodox Church, what did Ignatius of Antioch, that St. Ignatius, say back in 100 AD? The bishop in each church presides in the place of God. Let no one do any of the things which concern the church without the bishop. Wherever the bishop appears, there let the people be. Just as wherever Jesus Christ is, there is the Catholic Church. Interesting. So you're supposed to speak in the name of Christ, right? So go speak in the name of the Lord. You just brought the Catholic Church with you. The Catholic Church is the government of the Catholic Church. It's a government. It's a society. It has its own rules. Okay. But again, this isn't so much to do with what the church said. We want to get back to what it has to do with the state. Now, in Georgia, they have county ordinaries. Irwin County Ordinary Office. Someplace in Georgia. And when I was looking up county ordinaries, I found this history of Georgia. So let's see what this had to say. Sometimes the boundaries of early counties have been laid off without regard to the natural features, such as rivers and mountain ridges. Later, these natural features were used to form smaller counties with more local borders. Another important reason for a large number of counties is that in each new county came jobs and political power. New counties also meant numerous elected and appointed offices to fill, including sheriff, judge, county clerk, ordinary, and they put probate judge. So the ordinary, at one time in Georgia, was a probate judge. Now, for those who have been following for a couple of years, you remember the story about Jason in Georgia, who was trying to register a acceptance of deed into the county recorder's office, or whatever they call them in Georgia where you would do it. Here's the Register of Deeds office. And the lady wouldn't let them, and they had a little argument, and she tore his public record apart because he had it under the seal of the court, circuit court. Right? He went and got the certificate of authority for the notary. And so he complained about that, and at that time we had already known or heard before that the probate court is considered the court of inquest. And if you look at the definition of a court of inquest, one of its things to do is to inquire into if the wrongdoings of an officer, right, of a public official. And we saw from earlier in this that it's the ordinary that, what page am I on? This is 7. We should go read that again real quick. The county ordinary for adjudicating claims against an authority. And they also do marriage licenses. So if you look to see where the marriage license came from, I don't know if we're talking about the certificate here, we're talking about the license itself, to see what offices are on that marriage license. Because whoever that is also the county ordinary and can adjudicate claims against an authority. And the authority we're talking about is the judge sitting in your court case, because he's going to give a willfully false judgment based on perjury of witnesses. And why is that? Well, because nobody put in a sworn complaint. If there's no sworn complaint, how can there be a witness? There can't be. He's committing perjury. County government. So in 1789, the General Assembly provided for an inferior court in each county consisting of 5 justices. The inferior court had jurisdiction in judicial matters not entrusted to the superior court. The inferior court also had some administrative authority, providing for construction of county courthouses and other public buildings, levying taxes, overseeing maintenance of county roads. That sounds like the county commissioners or the road commissioners. And they made up a court. The inferior court had a third function, to serve as a court of ordinary. And in Rome and the Empire, the ordinarius, the ordinary, was the officer who first heard important civil and criminal cases. When you go into court with whatever that court case is you have, that really isn't the court case. The court case is something else that's happened somewhere else. And they're trying to use the longhand jurisdiction to get this enforced now. But the way you can tell this is you just look at the court case number. Sometimes it'll say 2013 CF 002262. Then next time you just see it 13 CF 2262. Doesn't have the 2000 in front, doesn't have the zeros. It has a different number. It's a different court case. Right? Where did the first one happen? The first one happened with the ordinary. The officer who first heard important civil and criminal cases. Well, we have a criminal charge we want to bring, so he would be the first one to hear it. Right? You don't take it to a judge first, you take it to the ordinary first. That's the way that's what I'm getting out of this. The court ordinary had a variety of functions, including probating wills and estates, determining the guardianship of children under 14, and issuing marriage license. That really sounds like a probate court. In 1851, constitutional amendment transferred the function of the court of the ordinary from the inferior court to a separate court of ordinary to be administered by a newly elected county official known as the ordinary. So in 1851, they started electing somebody called the ordinary. He's not called the county ordinary, but he will be the county ordinary, just like you're not electing the county sheriff, you're electing the sheriff. And once he's elected, he'll be the sheriff for the county. An inferior court continued with responsibility over other court affairs until 1868, and a new state constitution abolished the inferior court. This is, we're playing hide the peanut. Who's the ordinary, right? We need to figure out who's the ordinary after all this crap has happened. The 1868 Constitution provided that courts of ordinary shall have such powers in relation to roads, bridges, ferries, public buildings, paupers, county offices, county funds and taxes, and other matters as shall be conferred on them by law. Alright, so again, the courts of the ordinary were to do with roads, bridges, ferries, public buildings, yada 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 yada. A lot of that sounds like road commission stuff. Some of it sounds like it could be probate stuff for the paupers. However, in 1868, the Constitution also authorized General Assembly to create county commissioners in such counties as may require them and defined in their duties. Upon ratification of the 1868 Constitution, every county in Georgia was governed by the county ordinary. All right, so in 1868, every county was governed by a county ordinary. But this changed quickly. Hide the peanut. The General Assembly passed a local act creating 3-member Board of Commissioners of Road and Revenues. The next year, legislators provided for commissioners in 4 more counties. 15 counties switched from ordinary to commissioners. And by 1877, over half Georgia's counties were governed by county commissioners rather than ordinaries. The 1877 Constitution continued the ordinary as the governing authority of each county unless the General Assembly otherwise provided for commissioners of road and revenue. So unless you have commissioners for road and revenue, then in 1877 you were still governed by the ordinary. The Constitution was silent on how many commissioners were required, with the number, usually 3, determined by legislature in the local act creating the commissioners. In 1879, just 2 years later, in changing the form of government for Forsyth County, the General Assembly authorized a singular commissioner to run the county. Now we got one commissioner running the county. They're not going to call him an ordinary or probate judge, they'll call him a commissioner. Reportedly, Georgia was the first and only state to allow a sole commissioner form of county government. But in reality, there was little difference between a sole commissioner, S-O-L-E, and an ordinary as governing authority of the county. Both were a single individual elected by voters to run the county. Single individual elected by voters to run the county. In 1974, voters approved a constitutional amendment, changed the name of the office of ordinary to probate judge. All right, going from office ordinary back to probate judge. 1976 compilation by the Association County Commission of Georgia showed that only 2 counties, Town and Union, were still governed by a probate judge, while 26 counties governed by a sole commissioner. Separate local acts passed in 1984. General Assembly of Towns and Union Counties replaced the probate judge as governing authority with a sole commissioner effective the 1st of 1985. All right, so for towns and union counties, replaced the probate judge as governing authority with a sole commissioner effective then. Today, no Georgia counties are governed by the probate judge, while 9 counties are still governed by a single full-time commissioner. All right, so none are governed by the probate judge, but 9 still have a single commissioner. Interestingly, 7 of the 9 counties are in northern Georgia. Any decision to change the number of commissioners requires passage of local act. Any change would require pre-clearance of the U.S. Department under Voting Rights Act. One instance, Murray County, where county residents supported a switch from sole commissioner to a board of commissioners and later decided to return to sole commissioner form of government. People just can't make up their mind. And really it has nothing to do with us. These are people fighting for power that keep changing these things. In addition to commissioners, counties have other elected government officers known as constitutional officers, since they are enumerated by office in the state constitution. That's a good place to go look. Who are the constitutional officers in the Constitution? County constitutional officers include a clerk of the Superior Court, judge of probate court, sheriff, tax receiver, tax collector, tax commissioner. County constitutional officers are elected for 4-year terms, which have powers and duties provided by general law. In those counties where the office of tax receiver and tax collector have been consolidated into a single office. So you got this guy called a tax commissioner. Although dependent upon funding from the county commission, county constitutional officers have a degree of autonomy in carrying out their duties and not enjoyed by other government or county government officials. All right. Now, this is what you find online today. If you go in and look up county ordinary and put Georgia if you want to, you start finding hits like this. In Sumter County, they call them the ordinary/probate judges. And here they are from 1832. There was just one, so it looks like there's only ever one, either the county ordinary or probate judge, depending on what they're going with at the time. And right now, it's Judy Laverne Witten Reeves since 1993. So if you live in Sumter County and you have a problem with the law, with a judge that's given a willfully false judgment based on perjury of witnesses because there's no sworn complaint, they're trying to enforce a unilateral contract, the deed of trust, as a bilateral contract, which is fraud. The plaintiff is a fictitious entity. It doesn't exist. Not only doesn't it exist, it doesn't have a certificate of good standing. I mean, it really doesn't exist. It's just letters on paper. That's contempt of court. All things we pointed out before, we're just trying to figure out where to take it to. The County Ordinary Office. On this page, you'll find important information about County Ordinary Office based in Quitman, Georgia. And so in Quitman, Georgia, which is Brooks County, right, on Screven Street, is where you find the County Ordinary Office. Whereas Newberry County Council adopted ordinance something or other, budget ordinance, which established the county ordinary budget for fiscal year. So Newberry County has one. So maybe the thing we need to ask, because we're really just looking for justice, and the problem that we're having is that the judge, the sheriff, whoever, the tax collector, whoever is bringing this false accusation and won't prove it, and they say it's just the way we do it. Well, they're not following the law. And we need to find the ordinary who, reason of office, has an ordinary power to execute laws, to see that they're executed. The judge is only supposed to judge by the law, and the judge got his power to judge by the law from the ordinary delegated to him. But he doesn't have the power to execute the law. Only the ordinary does. And within civil governments, notably, forget the Southern United States, the role of the county ordinary historically involved the discharge of certain, often legal or legally related tasks falling to city and county authorities, such as licensing marriages and adjudicating claims against an authority. And that's what we need to do. We need to have a claim adjudicated against an authority. And so I have more on this in a couple days, but you might want to, especially if you have something going right now and you need to get an answer, you may want to start making a few phone calls. So you may start with the court clerk of the general court. Here they're called circuit courts, some places superior courts, whatever it's called. Talk to the court clerk and say, you need to know who in the county has ordinary power to execute laws. That's who we're looking for. Civic authority, who by reason of office has ordinary power to execute laws. And stay on point, right? That's what we need to know. Who's the civic authority who by reason of office has ordinary power to execute laws? That's who you need to go see. It looks like they have something to do with marriage licenses. Adjudicating claims against an authority, that's what we want to find them for, right? Because we want to have an inquest against a judge, whatever, for making a willfully false judgment based on perjury. It doesn't matter that he hasn't given away your property yet. The fact that he's letting it still go, knowing that there's no sworn complaint, is enough. I don't need to wait till they take my property to appeal. I'm going to appeal immediately. I appeal your decision to allow this to go on to the county ordinary. Who is he? He has the power to enforce the laws. That's the executive. He gets to enforce them. And judge based on the law. That's the judicial. That's what the judge is. He got his power to judge based on the law from the ordinary as a delegated power. Someone with governing power has it delegated to the person. That's the judge. So he doesn't have the power to enforce the law. And if you remember, I've said this so many times, but I just love to say it, that to defy the court of chancery shall rain the thunderous wrath of the Vatican upon you. Right? The civil authority has the great seal for the county. Whatever it is, I'm not saying it's the seal of the court of chancery. I'm saying in this ecclesiastic system they have, it's the seal that matters. It's that court of chancery. It may not be the court of chancery. The law vesting ordinary power could either be by ecclesiastic law or divine law. Either way, the guy who's an ordinary is there as a bishop. Basically, he's a bishop. I don't care if it is the civil authority, because ordinary power only comes from two places, ecclesiastic law or divine law. And many officers possess ordinary power, but due to their lack of executive power, it's the executive power that makes them the ordinary. Right? If not, they could have it like a judicial vicar, a judge. Judge doesn't have executive power. Got to find the guy with executive power. That's who you're looking for. And I'm not saying it's at the Catholic Church. I'm saying this is in the county, within the structure of the county. Them judges had their power given to them by the ordinary. So you could even ask the judge, who delegated you your power to be a judge? Who's the ordinary that delegated you your power to be a judge? Because I appeal your willfully false judgment to him. So, whether we say it's the lowercase circuit court or circuit court judge of the county or whatever it is, it's just another word. They have the office of ordinary. By reason of office has ordinary power. Who by reason of their office has ordinary power to execute laws. Get that answered and you'll know where to take your complaint. All right, we'll leave her there. Have a great night.